Hi, I'm attorney Gregory Dell, and I'm joined today by attorney Rachel Alters. And today's disability benefit tip is about principal financial long-term disability denials and initial steps that you should take if your claim has been denied. And Rachel, Principal is one of the smaller long-term disability insurance companies. They do individual policies, but they also do a lot of group long-term disability coverage, which means benefits provided by someone's employer. And so while we've certainly handled hundreds of cases, both individual and the group employer provided, regardless of which type of policy they have, I know they're going to be handled differently, but what's the first most important piece of information that you want from a claimant who's been denied benefits by Principal?
The first thing I ask when I'm on the phone with the claimant is I need to see the denial letter. If they haven't received it yet, then usually they're going to get it within a couple days, and I have them email it to us so I can go over the denial letter to determine the reasons why Principal denied the claim.
And within this denial letter from Principal, there's a certain threshold or standard that they have to include a variety of different information and tell people different things. What is it specifically that you're looking for in these denial letters that's going to guide you towards what your next steps are?
Well, what I want to see from the denial letter is I want to see the reason Principal denied the claim. They're going to explain in, whether it's a page or 3 pages as to what they reviewed. So they reviewed what medical records from the claimant, and then they're going to give reasons as to why they disagree with the claimant's treating physicians. So normally Principal will hire peer review physicians. Their opinions will be in the denial letter stating why it is they believe that they disagree with the treating doctors, or if there was an IME, an independent medical evaluation that was done, usually those results are also in the denial letter. So it's going to lay out the reasons why Principal believes that the claimant can go back to work on a full-time basis. Otherwise, they also put in, usually they're required to list what they believe what will it take to overturn the claim. So what Principal will often say is, we suggest that you as the claimant go get some additional MRIs or x-rays to provide more objective evidence of your disability, see additional physicians, and provide us some more objective proof so that we can review during the appeal process. If you choose to appeal, we can review this, which possibly may overturn the claim. And also it will provide them 180 days to prepare an appeal and submit it to Principal.
So one of the other things that a claimant who's been denied has the right to is what's called the claim file or the administrative record.
Right.
And explain what that is and why it's so important to get that before you start doing anything related to your appeal of the denial.
Right. The claim file is going to contain everything that Principal has reviewed from the inception of the claim. So what it is, it's going to contain all the medical records that they looked at and their peer review doctors looked at. It's going to contain all of the notes from the claim adjusters with their conversations that they've had, and the conversations that the peer review doctors have had with the treating doctors. It's going to contain the policy, which is extremely important to understand so that the claimant knows what their rights are under the terms of Principal's policy. So there's a lot of things that are in that claim file that the claimant needs, as well as if they retain a lawyer, the lawyer will need in order to prepare an appeal.
And then usually with these appeals, you're given 6 months to do it, and some people say, wow, that's a lot of time. But why is it really not that much time for a claimant who's been denied by Principal?
It's really not that much time because the 6 months goes by very quickly because usually, Principal's required to provide the claim file within 30 days. Sometimes it takes them a little bit longer, but it takes 30 days to get the claim file. Oftentimes the claim file is thousands of pages long, so we would need to review that claim file, and then we would have to order additional updated medical records, which often take sometimes 30 to 60 days to get from certain physicians. And then there's a lot of times where we would suggest additional testing for the claimants. That takes time. So a lot of it takes time, and then it takes time to actually prepare the appeal. So that 6 months goes by really quickly, and oftentimes the claimant doesn't always call us the day they're denied either, so we don't always have the full 180 days.
So the most important steps here are get that denial letter, because Principal usually calls you and says we're denying your benefits. People call us, they don't have the denial letter, so we really need that. And then the claim file, a claimant can request on their own, but certainly if they retain us, we'll go ahead and request that. And even if they request it, we can still get it later, but it's good to request it and get the ball rolling. What I always tell claimants is we offer a free initial consultation, which means we're going to review the denial letter, we're going to get on the phone with you. Having handled thousands of long-term disability denials and hundreds against principal, when you're on that initial call with us, we're going to know in a matter of 15, 20 minutes whether we think we can help you, what the chances of success are, how long it's going to take to handle this particular appeal, what it's going to cost for you to work with our law firm, and answer any and all questions that you're going to preliminarily have. And if you've never been through this process, it's more than just writing a letter and saying, here's some additional information. It's also thinking about the process. What if I lose the appeal? How's the court going to look at this? And no matter what state you're in or which federal court or what the policy says, there's 20 different factors that go into the applicable law that's going to apply and different strategies about how you want to write the appeal. No appeal is ever done the same. Everyone is almost like called a work of art that we do. So unlike the form denial letter that someone may get from principal, we're the complete opposite in doing a custom appeal when it comes time to that. So no matter where you live in the country, call Rachel, call myself, any of our lawyers. We welcome the opportunity to speak with you, answer your questions, and we're hopeful that we can help you to get your principal financial long-term disability benefits paid to you.